Several people are saying right now that Canada has a two-tier justice system that treats certain people differently from others. They'll cite recent cases of immigrants being given lighter sentences to avoid deportation, or Black or Indigenous criminals being given lighter sentences because of supposed systemic racism. But what if I told you there's more to the story? Because when you dig into this, you realize that it's not just that people are being treated differently, it is the reasons why they're being treated differently that are shocking. And yes, it is worse than you think it is. Hi, I'm Ali, and I've been involved in Canadian politics for almost a decade now, and covering it as a journalist for the last 5 years, working for Canada's top independent media outlets. And I've been investigating Canada's justice system, reading through cases, looking at media reports, and speaking to a prominent journalist with a legal background who has covered this issue extensively. And in doing that, I came across something shocking. I realized that it's not just bias from Canada's activist judges that have turned the justice system into a woke two-tier affair, but that actually race-based and immigration-based double standards have been baked into the system thanks to precedent-setting rulings and politicians who've either looked the other way or worse, abetted this. But before we get into exposing this shocking reality, be sure to like, share, and subscribe, and hit the notification bell to not miss the next upload. And now, let's get to it. This is Simply Politics. Journalism Commentary 1 year anniversary.
I don't believe journalism being funded by the government is the solution.
You have to rebuild the foundation. You have to retell the stories. Other news that actually matters.
I hence wanted to ask. I think they should answer their questions, especially if they're politically charged.
Recent cases of two-tier justice. There are many court rulings that showcase Canada having a two-tier justice system. These cases involve people who are either immigrants, people of color, or Indigenous peoples getting lighter sentences because of their identities. Let's go through a brief list. An Indian permanent resident who tried to buy sex from what he thought was a 15-year-old girl was spared from jail because a tougher sentence would have caused disproportionate immigration consequences. A South Asian immigrant who twice groped an 18-year-old girl was not convicted because the judge said a criminal conviction would have automatically resulted in deportation without a right to appeal. A non-citizen fraudster got a soft sentence because the judge took into consideration the potential immigration consequences. A Black man who killed a cyclist in a hit and run and then tried to cover that up got 100 hours of community service, with the judge pointing to his experiences with racism and bullying. An Indigenous man who terrorized and repeatedly sexually assaulted a 12-year-old girl was given a lighter sentence, with the judge citing the quote-unquote racism he faced. An Indigenous man in Manitoba got a lighter manslaughter sentence because he was Indigenous, with the judge citing Canada's quote-unquote shameful legacy of colonialism and attempted cultural genocide. And this is just a small sample of what's happening in our justice system. If I were to list all of the examples, I would be here all day. So what is driving all of this? Well, these rulings didn't appear out of nowhere. They came about because of something called legal precedent, which is when one judge rules something and then all the other judges are expected to follow that ruling unless that ruling is overturned by a higher court. And as we're about to see, in the case of two-tier justice, the precedents can be traced back to 3 major causes. To help break down and understand these causes, I spoke with Jamie Sarkanak. She's a columnist at the National Post who's written extensively about Canada's justice system and wokeness in Canadian institutions. Jamie holds a law degree from the University of Alberta and knows this issue inside and out. Cause 1. The Gladue Principles. The first cause goes back to 1995. That year, a bill was introduced into Parliament to adjust what politicians considered to be Indigenous overrepresentation, meaning that there are more Indigenous people in jail percentage-wise than they make up of the general population. Lawmakers added a new clause to the Canadian Criminal Code, which contains Canada's criminal laws, telling judges to consider the unique circumstances of Indigenous offenders.
Parliament changed the criminal code with a vague provision that talked about taking into account the circumstances, the unique circumstances of Aboriginal offenders, and they didn't specify what that meant. So Parliament kind of passed the buck to the courts.
In 1999, the Supreme Court heard R v. Gladue, a case that involved Jamie Tanis Gladue a young Cree woman who pleaded guilty to manslaughter after killing her common-law partner during a domestic dispute. This case led to the creation of Gladue reports. These are special pre-sentencing reports that outline an offender's trauma and background to help justify lighter or more restorative sentences, which is an approach that seeks to repair an individual rather than punish them. The result? Indigenous offenders can now be sentenced under a separate set of considerations. Now, this does not guarantee a lighter punishment, but it does often lead to reduced sentences compared to non-Indigenous offenders, and was why an Indigenous man who terrorized and sexually assaulted a 12-year-old girl was able to get a lighter sentence. And ultimately, as we saw, it was politicians who set this in motion with their 1995 law. Cause 2. Impact of race and culture assessments. The logic behind Gladue didn't stay limited to Indigenous offenders. Over time, it expanded into impact of race and culture assessments, also known as IRCAs. These are the reports that help judges understand how factors like racism, poverty, and discrimination may have influenced a Black offender's path through the justice system. These originate from a 2014 court case known as RVX. It involved a 16-year-old Black boy in Nova Scotia who was charged with attempted murder after shooting his 15-year-old cousin. The judge and Derek accepted arguments that systemic racism and community factors should be considered and decided to give the teen a lighter sentence. In 2017, that judge and Derek was promoted to the Nova Scotia Court of Appeal, and 4 years after that, in 2021, she used her authority in another landmark case, R.V. Anderson, to make race-based sentencing a provincial standard in Nova Scotia.
The court kind of took Gladue and applied it to a similar kind of thing to Black people. So there's a similar process where there's going to be some worker who does a report into this person's background, their racial background, the effect of systemic discrimination on this community that they're from.
Originally pioneered in Nova Scotia, this race-based process has since spread to other provinces. And therefore, two people convicted of the same crime can receive two different sentences because of the color of their skin. That said, not every conviction of a Black criminal results in a reduced sentence. And what have politicians done about this? Well, the federal Liberals have spent millions of dollars to promote the use of these race and culture assessments. Cause 3. The R.V. Pham case. Another type of identity-based sentencing appeared in 2013 in a Supreme Court case called R.V. Pham. This one imposed special sentencing considerations for immigrants. The case in question involved someone named Hoang Han Pham, a Vietnamese immigrant convicted of marijuana trafficking in Alberta.
Basically, when a non-citizen is getting sentenced, one of the factors that a judge has to consider, according to the criminal code, is collateral consequences that the offender might face or would face if sentenced a particular way.
The Supreme Court said that immigration, or more specifically, the person's deportation risks, was to be considered when dealing with a non-citizen offender. He was originally sentenced to 2 years in prison, which under Canadian law automatically removed the right to appeal a deportation. And the Supreme Court ruled that the lower court that gave him that conviction made a mistake by not considering how his immigration status would be affected. The court said that a slightly lighter sentence of 2 years minus 1 day would have avoided the immigration consequences while still being fair. And what did the politicians in power do at the time of the ruling? Nothing. Hence, since Pham, judges have routinely given immigrants lighter sentences so that they do not face immigration consequences, resulting in immigrants getting better treatment in Canadian courts than Canadian citizens. And while the Pham case involved a drug offense, this precedent is now being applied to egregious offenders, including those who commit sex crimes. And while this does not always happen, it happens frequently enough to warrant this video. And yet, as we're about to see, there are people who actually are more than fine with that. Why some people support this? There are people who support courts giving lighter sentences to Indigenous people, people of color, and immigrants, something which makes Canada's justice system two-tier. These people are primarily on the progressive left, and I believe it's important to understand their arguments in order to break them down. Here are some arguments in favor of race-based sentencing. A professor of sociology and criminology told CBC in March 2025 that Gladue reports are necessary because Indigenous offenders are overrepresented at the highest, most punitive level of every facet of the criminal justice system. Similarly, a law professor at Dalhousie University wrote in a 2020 paper that the impact of race in cultural assessments are necessary because it is important to take into account the historical and ongoing systemic anti-Black racism and the resulting over-incarceration of Black Canadians. However, Sarkondak noted that these arguments are flawed because they assume that every group commits crime at the same rate.
The systemic discrimination believers very much point to statistics, and they think they've got a slam dunk argument because they'll just say, well, Indigenous people are disproportionately imprisoned, Black people are disproportionately imprisoned. There you go. That's it. Everyone is... So the presumption is that everyone is committing crimes at the same rate. Everyone should be convicted at the same rate, and they're not.
Now, comprehensive race-based crime data in Canada is limited, but evidence from other countries helps add context to the situation. For example, in the United States, Black Americans make up 14% of the population, and yet 1/3 of the prison population. FBI data from 2019 shows that Black individuals accounted for more than half of arrests for murders and more than half of arrests for robberies nationwide. However, activists will argue that higher crime rates are themselves a result of racism and inequality. Sarkondak, however, also criticized these arguments, saying that blaming racism shifts the blame away from personal responsibility.
I don't think regular people buy them because you kind of need to abandon the idea of individual agency if you want to get there, because you're relying entirely on forces of society and then just human beings being pushed around by these forces, and that's it.
Now, I don't deny that some communities face real hardships. I personally know both Black and Indigenous people who have experienced racism in Canada. Like any society, Canada has a history of discrimination, but I don't believe a two-tier justice system is the solution. The answer to past discrimination is not future discrimination. And if we truly care about these communities, then we need to address the true root causes of higher crime. As for the lighter sentences for immigrants, Toronto immigration lawyer Panti Jafari defended the practice, arguing that having lighter sentences for immigrants to avoid immigration consequences is actually fair. They noted that for a person who is not a Canadian citizen, deportation can turn what was supposed to be a minor sentence for a Canadian citizen into something much more serious. Sarkondak, however, disagrees and noted that the real unfairness is when an immigrant gets a lesser sentence than a Canadian citizen.
It flies in the face of fairness, in my opinion, because if you're going to be shaving off a few months of someone's sentence or deciding to give them a discharge as opposed to a criminal record and a conviction on a file, and you're going to be doing that largely because they are not a citizen, that means that every Canadian citizen who's in that same situation is getting penalized for being a citizen.
Immigration to Canada is a privilege, not a right. Yet, instead of enforcing that principle, judges are giving sentences that are lighter to immigrants and therefore rewarding bad behavior. How to end two-tier justice. My friends, our justice system has lost its way. It shouldn't treat people differently because of race or immigration status. It should be colorblind, judging people by their actions, not their identities. Civil rights icon Martin Luther King Jr. famously said, quote, "I have a dream that my 4 little children will one day live in a nation where they will not be judged by the color of their skin, but by the content of their character. Politicians need to act to fix this situation, and thankfully, one already is. Conservative MP Michelle Rempel-Garner is working on legislation that would end consideration of immigration status when a judge is sentencing a convicted criminal who is not a citizen. But that's just the beginning, and more needs to happen. Reform must go further and address the race-based sentencing made possible by Gladue and the IRCAs. And conservative provincial governments and the federal conservatives, if they win the next election, need to appoint originalist judges, meaning people who interpret the Constitution as written rather than using it to invent new rights and laws. That is how we will end two-tier justice in Canada. This video was made possible thanks to generous support from people like you. If you want to support my channel, check the donation links in the description below. And be sure you are subscribed, and also check out my Substack at cantin-nantel.com. Until next time, God bless.